It's recording. Welcome, everyone. We'll get started momentarily. If you hear birds in the background, that's because one of our speakers is sitting outside, and I can give you a hint, it's not the one in Minnesota.
I'll mute. Here we go.
I like the birds.
A little bit of peacefulness.
All right, it is now 10 a.m. and I'm going to turn the program over to our Marie Sklodowska-Curie Fellow and the person who is in charge of the Transition and Energy Law and Governance series, Aubin Nzaou. Aubin?
Thank you, Victor. Good morning, everyone. It is my tremendous pleasure to welcome you all in this session, and thank you for joining our virtual lecture with our guest speaker, Professor Alexandra Klass from the University of Minnesota Law School. I'm Aubin Nzaou, and I'm a researcher at the Environment, Energy, and Natural Resources Center at the University of Houston Law Center. And I would like to say a few words about our monthly guest speaker series on energy transition and climate governance. Our program is funded by the European Commission in the frame of the H2020 program and Marie Curie actions. And our research covers a variety of topics in the field of energy law and climate policy. So every month, we convene speakers to address topics in conjunction with challenges of our time. This series will also feature as a guest speaker on March 12th, Professor Joshua Galperin from the University of Pittsburgh School of Law on uncommon law judging in the Anthropocene. For further information, please feel free to visit our website, www.law.uh.edu/EENR Center. So our program was approved for a Texas 1-hour CLE, and I'm going to share my screen so that you can see the slide. And now it's my pleasure to hand it over to Professor Gina Warren, co-director of the EENR Center and our chair this morning.
Thank you, Aubin. I really appreciate being a part of this great program that you have put together, and I'm looking forward to moderating today. So let me introduce you to our speaker. So Professor Alexandra Klass is a distinguished McKnight University Professor of Law at the University of Minnesota Law School. She teaches and writes in the areas of energy law, environmental law, natural resources law, tort law, and property law. She is co-author of at least 4 energy and environmental law casebooks, maybe even 5, and her scholarly work has been published in many of the nation's leading law journals. Professor Klass's research addresses regulatory challenges to integrating more renewable energy into the nation's electric grid, transportation electrification, oil and gas transportation infrastructure, and the use of eminent domain for electric transmission lines and pipelines. Today, she'll be presenting a recent piece, Eminent Domain Law as Climate Policy, which was published in the Wisconsin Law Review. It's a great piece outlining potential ways to change our eminent domain laws to promote clean energy projects and to disincentivize fossil fuels. I'm looking forward to this presentation. Thank you, Professor Klass, for being with us today.
Thanks, Gina. Thanks, everyone at the University of Houston for inviting me to speak today. Let's see, I'm going to share my slides here just to get going. Everyone can see that?
Yes.
All right. So, I'll start by, of course, saying that the irony that, this was scheduled for 2 weeks ago and was for an article that, is in part about sort of increasing the renewable electrons flowing into the grid. It certainly is, unfortunate and ironic that the reason that we had to cancel this was not enough electrons in the grid in Texas. But of course, that is a presentation for another day. I'm thrilled that we were able to reschedule this as quickly as we were, and that I can be with you all here today. So, as Gina said, this article was published in the Wisconsin Law Review in 2020. And, some law review articles, as many of you know, you get an idea, you think, oh, that's a good idea. And then you think about it for a while, and then you write some drafts and you work on it for a while. And the whole process, can take a year, can take more than a year. This was not one of those articles. I remember it was, kind of 4th of July weekend in 2019. And a lot of state legislative sessions were finishing up. And I kept seeing these articles about these new aggressive 100% clean energy laws that were taking place in several states. And I started looking at some of these laws. And this was, kind of the first big changes to some of our, renewable portfolio standards in a lot of states that had happened in a while. And I looked at these, and they all had these great goals. They were all focused a lot on the electricity sector, some on some others as well, some on, the economy as a whole as well. But to me, there seemed to be something missing. And so I decided to write this article to address that. I think I wrote the first draft in like a week because it just sort of all came together, and then worked on it for a while there. And I kind of want, what I'm going to do with these slides is really take you through my thought process, take you through the article, and I'm really looking forward to questions at the end. So I'll start with, here's some examples of these new state clean energy laws. Some of them were earlier than 2019, like the Hawaii one and the California one, but almost all the other ones listed here were either enacted in 2019, and I think there's one or two that were 2020. I'm going to go to the next slide just for a moment, just as comparison. So here's a map that many of you have seen that show, our renewable portfolio standards and now clean energy standards. The company that does these maps had to sort of come up with, it's not just renewable anymore, but it's clean energy standards. And you see where some of these are. And so, the old ones used to be, 15%, 20% renewable electricity by a particular date, 2020, 2025. These laws are much more aggressive. So if you look at them, you'll see that, the percentage renewables that utilities have to provide to customers in all of these are 50% or higher. And then there's sort of a new category of 100% carbon-free electricity. And these have, later dates, maybe 2040, 2045. But so this would be, carbon-free, of course, being renewable electricity like wind and solar, but also allowing for hydropower, for nuclear, potentially even fossil fuels with carbon capture sequestration. So more potential technologies and trying to hit 100% either goal or a mandate. A lot of these are focused just on the electricity sector, but as the note on this slide points out, some of these are economy-wide carbon reduction mandates. So they're going to include emissions from the transportation sector, for buildings, and then some of them have even additional, I would say, sub-mandates for solar or for offshore wind. And so then this puts them all together. A lot of the ones with the green hatching are the ones that have these clean energy or 100% carbon-free standards, in addition to the traditional renewable portfolio standards that are in blue. So we have these mandates, but you have to, I think, to understand where they come in, you have to know where we are in our energy use in the US. So these next few slides, provide a summary of where we've been, where we're going, and what we might need to accomplish some of these goals. So if you look at the history of energy consumption in the US way back to 1776 up until today, it's still predominantly fossil fuels, and our fossil fuels are increasing. So petroleum, natural gas, coal is on the decline for reasons we'll talk about, and renewables are increasing as well. But you see it's still, if we look at our energy system as a whole, which of course includes both the electricity sector and the transportation sector, there is a lot of fossil fuels still in our system, and it does not seem to be going away anytime soon. This looks at a snapshot in time. So this is this is just as of 2019, and it really tells the same story. Renewables are certainly a component here, but petroleum and natural gas are our big sources of energy. And this shows those energy resources flowing through our economy. And you see at the bottom, petroleum being a major source and being really powering our transportation system, and also having a role really everywhere else except the electricity sector, where it's very small, natural gas being everywhere. So we still see a big reliance on fossil fuels. In terms of our greenhouse gas emissions, we've done a good job of decarbonizing our electricity sector. There's still a lot of carbon emissions from it, but it is no longer our major, or at least our highest contributor to total US greenhouse gas emissions. That transportation now has that role ever since about 2016. But those are our two big sectors. And this graph just shows that over time. With electric power was always our biggest biggest source of greenhouse gas emissions. Now that is taken by the transportation sector, and that's going to continue. But electric power still has a lot of fossil fuels in it. This shows by fuel type in terms of our consumption of fuel versus the CO2 emissions that arise from that. Looking at the US in context, China is the world's largest greenhouse gas emitter. The US is second. But if we look at it per capita, of course, those numbers look very different. And per capita, the US is the leader in terms of greenhouse gas emissions, and China is further down the list. Now we look just at the electricity sector. So we're taking out transportation, which means petroleum drops out of our picture here. And you see, coal has been our predominant form, energy form to generate electricity. That has decreased over time. Now it's natural gas, but we're still replacing one fossil fuel for another. Renewable energy certainly has a bigger footprint now than it used to. We've got a lot of onshore wind in Texas and in other states. Nuclear power has been on the scene, since the 1970s, but there's still a lot of coal in our system, much less so, but increasing amounts of natural gas. And this shows a snapshot on the electricity side as of 2019. So renewables are 17%, nuclear 20%, coal 23%, and natural gas 38% is the leader. Once again, another slide on the electric power sector, looking at our sources of electric power and how those translate into CO2 emissions in that sector. What have we been building? You see that since 2013, 2014, there's no new coal additions in terms of electricity generation in the United States. That's not true in other countries, but that's certainly true in the US. We're building a lot more wind, we're building a lot more solar, but we're still building a lot of natural gas. And at least as of now, that does not seem to be taking a turn downward. So the question is, why is that? Well, we've got a lot of oil and gas, and we've had a lot of oil and gas to be extracted and used really since 2007, 2008 with the commercialization of hydraulic fracturing. So this shows where we have our big shale oil and gas plays in the US. Those of you in Texas are very familiar with this. This has been driving your economy for a long time. This shows that just the increase in crude oil production. We now have a lot of oil and of course, lots of oil in all of the various different regions in Texas and in Oklahoma, and then also into New Mexico and Colorado. This shows our crude oil production by state, lots and lots in Texas. Texas, you've always been a leader, now with fracking, even more so. And natural gas shows the same story. We are not running out of natural gas anytime soon. It's become a major player in the electricity sector all over the country. It used to be much more regional. And once again, we're not running out. There's a lot of money to be made. And there's a lot of pressure to develop these resources, both on federal lands and on private lands. Wind energy is on the rise. Those of you in Texas know that. Up here in the upper Midwest is also a big region for wind. And so you see this increase over time. And really the rise in wind started really increasing right around the same time we started with hydraulic fracturing. So we've seen a big increase in wind, and that's expected to increase. So that's a good sign in terms of trying to meet some of these mandates in these laws. But with regard to wind, of course, it's a regional resource. You have a lot in the purple and red and orange areas, not so much in the green areas, particularly in the Southeast. And so this is reflected in where we see our installed wind energy capacity, lots and lots in Texas for lots of reasons, but also in Minnesota, in Iowa, and lots more potential in the Dakotas, Nebraska, Kansas. Oklahoma is a real leader as well. And this shows the states in order of their installed wind energy capacity. And Texas is the leader, of course, by quite a lot. Solar is on the rise, both rooftop solar, utility scale solar as well. Costs have gone down, installations have gone up, both in terms of utility scale and small scale solar. Regional, but not in the same way as wind. Certainly, we've got much more concentrated solar resources in the Southwest and even in the Southeast. But in terms of the top 10 solar states, that's reflected, that regionalization is somewhat reflected there, but not everywhere. I mean, you've got New Jersey and Massachusetts and New York as well on that list. So oftentimes favorable state policies, state mandates can bring that along as well. So in order to bring the wind to population centers, solar as well, but less critical than wind, you really need electric transmission lines. So this was sort of one vision of the types of lines that we would need to build to bring that wind energy that's generated in the less populous regions of the Midwest to population centers. This is a picture of the proposed Clean Line Energy Partners lines, none of which have been built yet. Russell Gold has a great book called Superpower that just came out last week about specifically focused on that Plains and Eastern line. But the idea is we need more long distance transmission if we're actually going to get renewable energy into the electric grid and help states meet these renewable energy and 100% clean energy mandates. The National Renewable Energy Lab came up with their interconnection seams study just this past year that looks at where do we have solar? Where do we have wind? Where do we have wind and solar? Focus, you see that green area focused primarily on Texas. How can we take advantage of our different time zones, where we have our population centers and where we have our renewable energy resources to move renewable electrons around the country when we need them? And this is also from that study. And it shows how we really need to build some major high voltage direct current lines between our different interconnections, the Eastern interconnection, the Western interconnection, and ERCOT, and of course, down in Texas. And of course, even those of you who are not from Texas and had not necessarily known that we had 3 interconnections with Texas disconnected from the rest of the grid, you probably all know that now. After Texas's grid disaster from the last 2 weeks. So the idea here would be able to ship large amounts of solar and wind all over the country when it's needed to both deal with some of the resilience and reliability concerns by extreme weather, which we saw the last 2 weeks, but also just to decarbonize our electricity system. So it really would meet both of those goals. Okay. So up until now, I've been talking a lot about the current status of our energy system. Now, these clean energy laws are trying to change that, right? So to reduce fossil fuels, increase renewable energy. And so it seemed to me as I was reading these new laws is there was a tool that they just weren't using. And that's eminent domain, both increasing the amount of eminent domain authority that we give to some actors and decreasing the amount we give to others. So those of you who don't necessarily know a lot about eminent domain, we use it for all sorts of things. So we use it for highways and roads. The government exercises eminent domain. It takes private property for what's known as a public use, and it has to pay just compensation. Governments also engage in economic development and redevelopment, and in doing so, often have the power of eminent domain. But Congress and state legislatures have also delegated the power of eminent domain to certain private actors, oil and natural gas pipelines and electric transmission lines. So electric utilities and oil and gas pipeline operators have statutory authority either from Congress or from state legislatures to take private property because this type of infrastructure is defined by statute as a public use. So many of you are familiar with the case of Kelo versus City of New London. So this had nothing to do with energy, but it did have to do with eminent domain. And here is a situation where a city used eminent domain for a redevelopment project, the City of New London, Connecticut. And the question, it was challenged, and the question was, is economic redevelopment for the purpose of creating jobs, for increasing tax revenues, is that a public use under the Fifth Amendment to the US Constitution? The court held that it was, which followed earlier court decisions interpreting public use very broadly, but it was a 5-4 decision, so very close, which was surprising. And there was a lot of public backlash against that. The idea is, why should you be able to take someone's private property, redevelop it, and give it to a new corporate headquarters or something that the public isn't really using just because it's creating jobs and increasing tax revenues? So many states either amended their constitutions or passed new statutes limiting the ability to use eminent domain for economic redevelopment. These state law changes were really focused on the government use of eminent domain. It didn't focus at all on private party use of eminent domain, like an oil pipeline or an electric utility trying to build an electric transmission line. So, as I mentioned before, sometimes it's Congress and sometimes it's states that give the power of eminent domain to companies that are involved in energy transport. So interstate natural gas pipelines, eminent domain exists at the federal level. So the Natural Gas Act of 1938 created, delegated to natural gas pipeline companies the power of eminent domain. So even if a state doesn't want an interstate natural gas pipeline company, they can comment, but they can't really provide a veto because there's federal eminent domain authority once that pipeline gets a certificate of public convenience and necessity from the Federal Energy Regulatory Commission. That's not true for interstate oil pipelines and natural gas liquid pipelines. That's all done at the state level. So you need state eminent domain authority. Most states provide that. And also true for interstate electric transmission lines. That's with a few exceptions, that's all done at the state level. And as I mentioned before, the legislative reforms after the Kelo case really didn't change these laws at all. But keep in mind, Kelo was a 2005 case. Fracking for oil and gas starts around 2007. So all of a sudden we have oil and gas, and we have lots more of it than before, and we have it in new places like Pennsylvania, like North Dakota. So we have a massive build out of oil and natural gas pipelines. We also have this growth of renewable energy starting at the same time, as I showed you on those graphs. We have an increased concern over climate change as well. So this is all happening after the Kelo case and after the state reforms that were prompted by the Kelo case. We also have some limited efforts by Congress to allow the Federal Energy Regulatory Commission and the Department of Energy to help build interstate transmission lines and not have this just be a state issue. And so there's some limited effort to do that right around 2005. So we have a lot of different things happening at the same time that are not specifically focused on eminent domain, but are influencing what's happening right now with regard to eminent domain. So now that in the post-Kilo era, lots of people are thinking about eminent domain and thinking eminent domain is not so good. Now as all these new oil and gas pipelines are coming through, you see a lot more opposition to oil pipelines and natural gas pipelines, and particularly a focus on, are these a public use? And many courts continue to say that they are, that it's up to a state legislature to change that. You have the Illinois case that's cited here, the Ohio case, but you have a few courts here and there saying, well, if the oil or the gas isn't going to residents of our state, then we don't really think that there's a public use, and it violates changes that we've made to our Constitution since Kilo. So we see just a lot more focus on some of these state lawsuits dealing with oil pipelines. And also we've kind of got new organizations working together. So we've got kind of the more right-wing property rights or libertarian property rights groups working with a lot of the environmental groups who are each opposed to pipelines and eminent domain use of pipelines for different reasons. We see this on the federal side as well. We have federal lawsuits challenging eminent domain authority for natural gas pipelines. Lots of lawsuits challenging FERC's grant of eminent domain, citing the Kilo case, court decisions scrutinizing the use of eminent domain for pipelines designed for export. How is it a public use if all of the natural gas is going to Canada? Can you use eminent domain can a natural gas pipeline company exercise eminent domain to take state lands? That's the Penn East case, which the US Supreme Court recently decided it would grant review of. So the Supreme Court will give us an answer on that. So lots and lots of activity on eminent domain for these sorts of things. We've even seen some state law moratoria on oil pipelines. The Palmetto pipeline, which was a natural gas liquid pipeline, was going to go through South Carolina and Georgia. The landowners didn't like it, and South Carolina put a moratorium on the use of eminent domain for oil pipelines. Georgia did the same thing. And then the moratorium expired and it was replaced by a law that made pipeline companies jump through a lot more hoops in order to build a pipeline in the state. Of course, these were not prompted by climate change concerns, but really just being responsive to landowner concerns with regard to this particular pipeline. Okay, so now I come to the main thesis of the paper, which is I have always thought about eminent domain as an incentive. It's an incentive that we in the United States, we give to the private sector to build projects that are often built by governmental entities in other countries. So it's like a tax incentive. So I think we need to think about what projects do we want to give incentives for, like eminent domain, and which ones do we not? So for these states that are enacting these very aggressive clean energy laws, maybe they should look at the use of eminent domain in their state law to eliminate or reduce the use of eminent domain for fossil fuel projects, and then expand the ability to use eminent domain for clean energy projects like electric transmission lines. Because we saw from what's happening in our energy system that yes, we have a rise of renewable energy and renewable energy development, but fossil fuel energy development is not going away. We still have a lot of fracking for oil, for gas. There's a lot of money to be made. There's a lot of infrastructure being built. And so if these states want to kind of flip that and have and increase the amount of renewable electricity that we have in the grid, and moving away from natural gas, moving away from oil in the transportation sector, perhaps they should think about why they are giving eminent domain authority to build new projects like this. There could also be changes to the laws that govern state public utility commissions. They are often the regulators who approve eminent domain authority or approve permits for these projects. So projects that promote clean energy, maybe those are a public use, and ones that don't promote clean energy are not a public use. So we should be redefining what is a public use under these state laws, or at least the states that are committed to these 100% clean energy goals should be thinking about that as well. So, this really argues for a more comprehensive approach to incorporating eminent domain as part of climate policy, rather than really having it be something totally separate. So some options for new legislation. This just provides a little more detail on these ideas. So states could eliminate completely eminent domain for oil pipelines. Congress, if it wished, could eliminate the use of eminent domain for interstate natural gas pipelines. There's certainly an opportunity to redefine public use in these state statutes, to redefine need in certificate of need legislation. This is true both for pipelines and for electric transmission lines, and including climate and clean energy considerations into these definitions, not just in separate statutes that are focused on these 100% clean energy mandates. So I think there's also opportunities for the Biden administration to get involved in this. So Avi Zevin has and some of his colleagues before he went into the Energy Department recently has a great new paper out as to what are the tools that we have already in the Energy Policy Act of 2005. I mentioned that law briefly. To build more transmission lines. This interconnection seams study is really important in terms of thinking about how can we create the types of partnerships and financial incentives to actually build one of these, basically an above ground or an underground supergrid. President Biden has said that he wants to have climate be an emphasis throughout all of the agencies. So thinking about permitting in the Army Corps of Engineers that's very involved in some of the natural gas permitting in terms of the stream crossing. So we want to be discouraging rather than encouraging new fossil fuel infrastructure. There's ways to do this through FERC as well, looking at natural gas pipelines. Current FERC chair, Richard Glick, has been talking about this for a long time, mostly in dissent. Those might not be dissents anymore. And also just grants and planning for financial and other support for this idea of a just transition. Certainly there are communities that are going to be losing fossil fuel generation. That means losing a lot of revenues. Can we host some of these renewable generation plants and transmission lines in these communities to try to make up for those lost revenues? Here's just a slide with some further reading in terms of some other work that I've done on this topic. And with that, I'm going to stop sharing the screen and would love to take questions and have a good conversation here.
Gina, we're having a bit of a hard time hearing you.
Oh, you can't hear me?
Now
am
we
I
can.
okay?
Thank you. Now you're good. Thanks.
Okay, sorry about that. I'm sharing the internet with my son who's in virtual school right now. So thus I'm outside and he is inside trying to do his work. Okay, so let's start with, I love this question. So, as you indicated, a lot of the eminent domain power comes from the states. And you even mentioned the federal eminent domain authority potential. And so I have a question specifically originating in the executive branch. Should it come from that instead of Congress, which raises two potential issues, one about federalism and one about separation of powers. At the same time, this question, they would like to know if you envision any justification for this sort of federal power if justified as a necessary action to address a climate emergency.
Okay, so yes, a lot of eminent domain power comes from the states. In terms of the executive branch, I think right now the idea is for it to come from the executive branch, they would be looking to existing congressional authority. So the Energy Policy Act of 2005 did give the Federal Energy Regulatory Commission and the Department of Energy the ability in certain circumstances to provide a siting permit and use eminent domain authority for interstate electric transmission lines that were needed to meet concerns over congestion, not enough space on the lines. This was after the 2003 Northeast blackouts. FERC and Department of Energy tried to use that authority, but the courts sort of struck it down. Not all the courts, but like there's a Fourth Circuit decision that limited FERC's authority. There was a Ninth Circuit decision that said when the Department of Energy tried to create one of these national interest electric transmission corridors, it didn't consult the states properly, so it was more of a procedural issue. So FERC and DOE at that point just sort of gave up. But they didn't have to give up. They could have tried again. They could have pushed this more. I mean, part of the problem is it is this federalism issue. People don't like eminent domain. They just don't, right? And so federal agencies are going to be very, very careful about trying to use the authority, even the authority that they have, because there might be a backlash and people are going to then run to Congress, and Congress might take away that limited authority. But right now they're not using it at all. So at least the Zevin et al. Paper argues there's a lot of ability there, to use the authority that Congress has already provided to these agencies. There's another provision of the Energy Policy Act of 2005 at section 1222 that allows the Department of Energy to actually partner with a private company to build a transmission line that's designed to integrate more renewable energy into the grid. And so, and DOE actually did start a partnership with Clean Line Energy Partners for that Plains and Eastern Clean Line. And ultimately, the project kind of fell apart during the Trump administration. But the playbook is there to do that again. And I actually think section 1222 of the Energy Policy Act is something that the Biden administration could easily pick up. They've already created the regulations for that. You now have a Department of Energy that's interested in doing this. And when the federal government is actually building the line, then there's federal eminent domain authority because the federal government's building the line, as opposed to a private party that needs a congressional delegation of that eminent domain authority or state delegation. And the case law is pretty good on that. So I actually think that is a promising, it has some promise. And then maybe DOE could try one or two projects that way. And if it worked, then maybe you go to Congress to try to get additional authority for that. But I think it's important to think about not just expanding eminent domain authority for the projects that we want, but really reducing or eliminating eminent domain authority for the projects that we don't want. We usually don't have those conversations together. We either do one or the other, at a particular time. So the Natural Gas Act of 1938, big push to build natural gas pipelines. And so all of this eminent domain authority, is granted. After the Kelo case, people didn't like eminent domain authority for economic development. So we're going to get rid of eminent domain authority for that. But here we want to accomplish a particular goal of clean energy transition, which means we should put in my view, we should put additional burdens up to using eminent domain authority to help build the projects that we don't want. At least in these states, there's a policy that we don't want new fossil fuel projects, and we want to eliminate that in our energy system. And we want to increase the renewable projects. Mandates help, tax incentives help, but I don't think eminent domain as a tool should be off the table.
Actually, before we leave this question, Alex, and I don't know if you thought about this, and I know I have not, but I think one of the other things the question might be getting at is the concept of climate emergency. I've heard that term tossed around so that Biden could use that as justification for just doing all sorts of things, kind of like Trump did with the border wall emergency, like diverting funds. And remember, we went through that whole discussion, can you really do that? And da-da-da-da-da. And I wonder have you heard anything about that? Because I've heard a little bit about climate emergency talk before to justify lots of things, but I haven't heard it related to this.
In theory, yes. Because we don't know what the outer parameters of that are. I would doubt that as a political matter, the Biden administration would want to go around using a lot of eminent domain authority for that. I think there would be other tools it would go to first, just because of the political backlash with regard to eminent domain. I could see more financial tools, more incentives. I think I could see sort of trying to use things that are not as politically charged as eminent domain. I think if you're going to use eminent domain, you want to go, it's not something you're going to use quickly. You're going to have maybe a targeted project that you would use it, but I think you would try to use, like, at least if it was a transmission line, you would try to use the section 1222 of the Energy Policy Act, because there's already a process to go through, as opposed to just picking some other project, out of a hat and saying, oh, we're going to use eminent domain authority for that. I think it in some ways it can be a crude tool. And so I would think they probably should go to other approaches first.
Well, I was also wondering, and there's a question on this too. So if you take away the right of eminent domain for fossil fuels, are you actually a taking happening of the fossil fuels and creating a stranded cost, stranded assets? And how would that be addressed if you no longer can use eminent domain as fossil fuel, but you could for renewable projects?
So I don't see that being a taking, because it's not like you're forcing companies to take their assets out of the ground that they're already making money on. You're just taking away an incentive to help them build something new. So if you apply, whether it's Penn Central or anything else, on your sort of expectations, I don't think you have an expectation that the law will never change and incentives won't be there in the future. So, I mean, someone might make that argument, but you don't really have a stranded asset problem, because we're talking about new infrastructure rather than existing infrastructure. And of course, at least in the article, I'm not arguing that you should never issue a permit for an oil pipeline or a natural gas pipeline. I'm just saying you might not be able to have the power of eminent domain, just like to build generation facilities, you don't have the power of eminent domain for the most part. So it's not like you can't get a permit. It's just that you need to use voluntary transactions to get those easements. That makes it much more difficult to build the project. And when you have a linear project, whether it's an oil pipeline, natural gas pipeline, electric transmission line, it's very difficult to build that without eminent domain authority. But I guess I just don't see the takings argument. But it's a good question. And I think I addressed that, because I think Chris Serkin and some other people have some articles about, sort of takings, sort of climate change related takings in terms of, changes, but that's more to, I think, existing investments and existing infrastructure.
All right, great. I have another really great question here from Jared Gamble. Let's see. It says, you mentioned when you were giving your presentation that landowners didn't want the pipeline. And there's a question about, are you suggesting that landowners should have the freedom to object to oil pipelines, but not renewable powered pipelines, or renewable projects would be my guess, transmission. And if so, why? Is this a ESG value situation? And so some of that's starting to come up here. And what about the full life cycle costs of some of these renewable projects, such as solar, and can't carbon emissions from oil be more easily offset through technologies such as carbon capture and technologies?
Well, so, that's all a policy decision. Normally, landowners can object to anything and say, we don't want anything on our property unless the government grants either themselves exercises the power of eminent domain, saying, no, this project is a public use, so you get just compensation, but you no longer have the right to object to that. So if the interstate highway is coming through, you say, I don't want this highway on my property. The government can exercise eminent domain, pay you the fair market value of your property, but you don't have a right to object. So up until now, at least under state law, there is the right of eminent domain for oil pipelines. There's the right of eminent domain for some electric transmission lines. And so the question is, to what extent does the state, if the state's in charge, or Congress, when Congress decides that it wants to exercise authority, when are they going to take away that right for you to object? And so what I'm suggesting in the paper is that we should increase potentially eminent domain rights for renewable energy related projects and decrease them for fossil fuel projects, to sort of flip what the current use of eminent domain is now. But either a state legislature or Congress has to make that decision. So as to your question, well, are there maybe some natural gas projects or some other fossil fuel projects with carbon capture sequestration that actually are helpful in terms of energy transition? Well, so, and I addressed that in the paper a little bit. In those situations, depending on how the state writes the law, you could then make your case is this is a project that will help with to meet the 100% clean energy goals that are set out in the statute. So I should be able to exercise eminent domain for that. And if the law is written appropriately, that you're allowed to, that a public use is defined as a project that will help meet those clean energy transition goals, then that potentially could allow eminent domain for those projects. So it really depends how the law is written. And what I'm arguing here is that eminent domain should be a tool and should be brought in to those determinations, and you should put climate and clean energy transition into your definition of public use as you're making these changes. And by you, I mean state legislatures or Congress, to the extent Congress gets involved.
I think it's interesting this morning, and I know Tracy Hester was on this call, sent an email about a city in California that was banning gas stations. And because that was what was consistent with their policy for trying to increase renewables and decrease fossil fuels. Had you seen anything like that? Because that seems like that's very consistent with what it's just one of those tools in the toolkit.
Right. I mean, you're seeing that with lots of cities that are banning the use of natural gas in new building construction, right? So you're seeing lots of cities in California, and I think city of Seattle just passed one, and some states are thinking about that. Now, of course, you also have states that are preventing local governments from doing that, even in some cases, even before local governments have considered it. It's like, don't even think about it because we're now preempting you from doing that. I think Arizona did that. I have a new article that's coming out on state local preemption that talks about that issue. So yes, that's another tool that policymakers are using. So you can either ban something entirely, or you can just say, we're going to take away one of the incentives for that project, which would be eminent domain. So actually, my proposal on making changes to eminent domain is a much smaller step than like a total ban on gas stations or a total ban on natural gas.
All right. So I had a question. So John posted a question, of course, about Penn East. And so I know you mentioned Penn East in your presentation, but can you maybe elaborate on how you think the upcoming decision in the Penn East case is likely to affect this discussion to promote renewable energy development?
Okay, hi, John. John, of course, is the expert in all things regulatory takings and eminent domain. So, and John and I actually had an email exchange about this a few weeks ago. So, if the Third Circuit decision is upheld and you can't use the and you can't use the eminent domain provisions in the Natural Gas Act to take state lands, I don't think it has any impact on renewable energy development because you already don't have that eminent domain power for interstate electric transmission lines. If the case is upheld, what it means for natural gas, I can talk about natural gas pipelines first, and then I'll bring it back to transmission lines. One of the things it means for natural gas pipelines is that FERC would have to exercise that eminent domain authority. So it's not that FERC can't use eminent domain authority to build a natural gas pipeline. Federal agencies can have delegated authority from Congress to exercise eminent domain authority against the states. And I don't think, the state of New Jersey is arguing that. They're just saying you can't delegate that to a private party, because the Natural Gas Act doesn't give that power to FERC. It gives it to private companies, natural gas operators. So the fix would be, if you wanted to take state lands for a natural gas pipeline, is Congress would have to amend the Natural Gas Act and directly give that power to FERC, which I actually think would be a good thing, because right now FERC can sort of avoid the political consequences of the use of eminent domain, because they're not exercising eminent domain. They're just saying, well, we're approving this pipeline, and pipeline, you go off and do that, and you take all the flack. So, I think then FERC would have to be responsible for that. And, I think when it comes to electric transmission line as well, I think you want the federal agency involved in that, if it's going to, particularly if you're going to be taking state land. So let's say you had the same circumstance with regard to an electric transmission line, and you wanted to use state lands. So it should be FERC or the Department of Energy that's actually exercising the eminent domain. I don't know that you need to delegate it to the private sector. I think you probably have more political accountability if it stays with the regulator. And of course, if the Supreme Court, reverses the decision, it just means that at least under the Natural Gas Act, states have, a lot less tools available to avoid that in terms of natural gas pipelines.
All right. So I have a question. I'm not sure. Maybe you can think about what this might be trying to get to. I have a question about eminent domain and the situation of energy transition when it comes to lands. Doesn't this foster inequities for tribal lands? So maybe if you could just maybe talk a little bit about how this could affect tribal lands and what your thinking is on that.
So I'm not an expert in Indian law, but my understanding is actually there's a lot less eminent domain power when it comes to tribal lands, at least, for instance, for oil pipelines, that's sort of that state delegated authority to the private company. And I don't think they can use eminent domain. So I think there's a couple of situations going on around the country where, an easement agreement, I think this is happening in Michigan or Wisconsin. There's an easement, long-time easement for, I think it's for an oil pipeline, and the easement expired and the tribe says, we don't want that pipeline anymore, take it out. And the company has no choice but to take it out because there's no state eminent domain authority over, over tribal lands because they're equal sovereigns. Different, I think, when it comes to the federal government, but even then, I think when it's tribal land, there's quite a bit more leverage for the tribes. And there's examples where the tribes have been able to get, sort of very lucrative kind of royalty payments and other sorts of things that private parties can't get because of their sovereignty. So I think that would be the case whether you're talking about an electric transmission line or a, oil or natural gas pipeline.
Okay. Victor, I know you had a question about interconnection. Do you want to?
Well, this was just from the beginning when you were showing all the interconnections. Of course, I'm still thinking about the crisis of 2 weeks ago. And I was thinking, there's so much going on with the idea of whether Texas interconnects or not, including FERC jurisdiction, et cetera, et cetera. But it struck me that if we were going to do any interconnection, it probably should go to the west to carry the solar and wind west, because it just, you can connect obviously from the end of the transmission lines that take it to the east, going east as well, but the source of the power is in the west. And I just wondered if that's possible to do a western interconnection and not east, but then that probably still gets you into FERC jurisdiction. So.
Well, yes or no. I guess it depends whether FERC wants to exercise jurisdiction, because it's not like Texas doesn't, that ERCOT doesn't have any connections, right? There's just very, very few. And, I don't know all the details of it, but I think there were reasons that, FERC doesn't want to necessarily antagonize Texas. So maybe they work out some deal that, you can have some additional DC lines, but there's still limited Texas jurisdiction. I don't know if that's fair. Why does, Texas, get to be connected and not have FERC jurisdiction? But it seems like there might be some way out of that. A lot of these reliability standards, that they're talking about now, those are NERC standards, and those do apply in Texas to the extent NERC wants to make them mandatory and enforce them. So, I do think there's opportunities for, Texas regulators and politicians to sit down with FERC, to sit down with others. You never want to waste a disaster. And this may be a nice opportunity to both obviously rethink internally some of the weatherization and reliability standards in Texas. And I think to some extent that can be an internally Texas decision. But I do think, the ability in emergencies for Texas to be able to import is important, but most of the time it's for Texas to be able to export, because you've got so many wonderful wind and solar resources in addition to your fossil fuel resources. You've always been an energy export state. That's, your whole economy. And to do it on the electricity side with all your renewable energy resources just seems like an amazing opportunity, a financial opportunity, an investment opportunity. And then it also has the added benefit of allowing energy to flow the other way in cases of emergency. So it can be a win-win, and maybe, the massive scale of this disaster will cause enough people in charge to think about those options.
What I think is interesting too, and this, I don't want to get off too much on a tangent, but wind at many times of the year now in Texas can be supplying over 50% of the electricity at any one time. The difference is, but almost always that gets used. Like, we don't stop it because of the dispatch of the low power, the lowest cost power. So it's not as if that's being wasted and would need to be transferred to the West to keep it from being wasted. So that's kind of a whole other market thing that's interesting to me. But anyway, that's a tangent. So we'll look forward to talking about that more later. Thanks.
Yeah. I see there's a question from Danielle Meinhardt, who's my former research assistant and my co-author on the transporting oil and gas article in the Iowa Law Review, which is one of the first things I wrote on oil and gas pipelines. She's an attorney at EPA in Seattle now. So I see that she's asking, can you link to specifics regarding how advocates could go about limiting the use of eminent domain for fossil fuel projects? So frankly, the Sierra Club and NRDC and other environmental groups have done an amazing job on that over the last 4-8 years in terms of partnerships with local property rights groups and others. Michael Bloomberg and sort of, his funding has done a lot there too. So I do think, and there's other groups involved. In the Niskanen Center has done really good work in terms of amicus briefs that are always getting cited by the court. So I think environmental advocates have really, really focused in on these infrastructure issues, which is why, these cases like Penn East are, going up to the Supreme Court, because before, you had local landowners who would oppose projects that impacted them directly. And, environmental groups, they were more interested in opposing electric transmission lines because you could see them and they interfered with scenic and natural areas. And, pipelines were underground. And so that's really flipped. You've got environmental groups actually that have not just ignored transmission lines now, but supported them. So you see local and national groups, really trying to get these lines built. So building the type of infrastructure we want, and then teaming up with some of the landowner rights on the fossil fuel projects. So I think, a lot of the cases that are moving their way through the federal courts on natural gas pipelines and then also on oil pipelines, that is a lot of resources that that nonprofits and advocates have brought to bear, and that's why those cases are as effective as they have been so far, is because you actually have more resources for them.
Well, thank you. This has been excellent. I feel like I learned so much and so many things to think about. I have multiple questions of my own that I might send you in an email, but I really appreciate your time. Thank you so much for being here, and then such a great presentation. So everyone knows that the slides and the recording will be posted on our website. And so anything else? Do we need to re-show the CLE just in case somebody missed it? But I think that pretty well does it. Victor, any last thoughts or anything to add?
This was great. Thanks, Alex. And I'm so glad we get to continue working with you. It's wonderful. Thank you.
Great to work with all of you, and thanks for the invitation.
Thank you.
Thank you.
Thank you.